Hi, I'm Henrietta Poindexter with the Indiana Civil Rights Commission. I am a program director there who investigates the complaints of discrimination based on housing violations. Today I'm talking about the housing violation. You say, what is fair housing? Fair housing is based on the premise that housing should be a free choice. That means that if you qualify for the rental or for the purchase of or even to obtain land, that should be based on objective criteria. The Indiana Civil Rights Law, as cited in Indiana Code 22-9, states, it is the public policy of the state to provide citizens equal opportunity to purchase or rent property. What property is covered under the Civil Rights Law? Well, all property is covered under the Indiana Civil Rights Law. That means commercial and residential property, regardless of how many you have or where it's located, as long as it's located in the state of Indiana. Now, the only exception to the Indiana Civil Rights Law as compared to the Fair Housing Act is the protected class, which I will speak of later on. You may wonder what other law governs housing situation. The Indiana Fair Housing Act also governs housing violation. The Indiana Fair Housing Act was established in 1991 and it prohibits illegal housing discrimination based on 7 protected classes. It applies to virtually all areas of housing transaction, and it applies to both privately and publicly owned housing. Now, protected classes that are covered under the Fair Housing Law are at this time limited to these particular 7 classes, which is race, color, sex, religion, national origin, disability, and familial status. Let me point out, however, that familial status is not covered under Indiana Civil Rights Law. It is only covered under the Fair Housing Act, the State Fair Housing Act, as well as the Federal Fair Housing Act. I'd like to go in depth about some of the definition of those protected classes. When I speak of disability, the definition of disability is 3-pronged. Disability could be 1, a physical or mental impairment which substantially limits one or more person's major life activities. 2, has a record of such impairment. 3, regarded as having an impairment. Familial status means children under the age of 18 are living in a household. Those children could be adopted, your natural children, foster children, or ladies who are pregnant at the time of rental or purchase also are considered to have status of familial status and protection. Let's just set aside and see if you're able to answer questions based on the information that you have received thus far. Al and Peg have 2 children and are looking to rent a 2-bedroom apartment at Alpha and Omega Apartment. The manager denies their application. His reason was that the apartment is for adults only. However, Al and Peg see that there are persons living there who are in their 20s and 30s. They see no children. Can the manager deny Al and Peg an apartment because they have children under the age of 18? The answer is an overwhelming no. Alpha and Omega Apartment must meet the criteria for senior housing. That means 55 and up, or everyone who lives there 65. Otherwise, the manager cannot refuse a family solely because they have children. You may wonder what dwellings are covered by the Fair Housing Act and the Indiana Civil Rights Act law. Any building or structure intended for occupancy by one or more family. Also, it covers vacant land intended for housing. Along with coverage comes some exemption. The owner who has fewer than 4 single-family houses at one time. And there are some specifications that's connected to that exemption. The house was sold or rented without the use of a real estate service or prohibited advertisement. It applies to only one sale or rental within a 24-month period if the owner was not the most recent resident. Another exemption is a building that has 4 individual units, but the owner occupied at least one of those units. That exemption is generally referred to as the Mrs. Murphy Law. Another exemption is an exemption to religious organization. Now that is limited to sales or rental to people who are in the same religion. This does not apply to non-commercial transactions. And with this exemption, it cannot be based on race, sex, national origin, religion, or disability, the usual protected classes. There's an exemption for private clubs. This exemption is strictly for private clubs and for club purposes only. There is no commercial transaction in the rental or sale, and it may not exclude persons based on race, color, or national origin. And now we'll talk about the exemption for housing for older persons. Housing for older persons may exclude family with children. This is sort of like an exemption that allows you to discriminate, but it has its restriction and limitation. Housing which is intended for and solely occupied by persons 62 and older. Housing which is intended for persons 55 and older, which is 80% occupied, at least one person 55 or older. So the second type of senior housing allows for a younger spouse. Let us talk about some example of possible housing violation. White tenants in a building that excluded minority were aggrieved on the ground that the management of the housing project affected the very quality of their lives. Now this is an actual case that we had in our agency. So management put forth a law that governed who was the visitors. A management company cannot determine who may visit their tenants. Another example of a possible housing violation is a live-in boyfriend was held to have standing pursuant to the act because of a minority was forced to discontinue his visit to his girlfriend's house. Now this case was out of Maryville. A Caucasian female with a biracial baby moved into an apartment building, and about a week later, the father of the child visited the tenant. The management was unaware that the baby was biracial because of the light complexion. But upon seeing the father, management issued an eviction notice for the white tenant. She put in a complaint of discrimination, and it was found to be in violation of the Fair Housing Act. The boyfriend as well could have been an aggrieved person, but he did not put in a complaint. The Fair Housing Law and the Fair Housing Act prohibit specific activities: refusal to rent or sell, misrepresenting availability, refusal to negotiate with a person, imposing different terms and conditions. If a management would require the disabled person to pay a bigger deposit, fearing that his or her wheelchair may damage the apartment, that is different terms and could be a violation. If management would cause a family to live on the bottom floor because he or she have children, that could be a possible violation. When different terms are imposed on tenants of a particular class, those are deemed to be violation. Steering is discouraging or encouraging prospective home buyers or tenants from selecting property because of the racial or ethnic composition of the neighborhood. And there's also blockbuster, which is pressuring individuals to sell their home because of members of a protected class are moving into a neighborhood. Then there is redlining. That's denying or imposing different terms on mortgage loans or insurance coverage because of the ethnic makeup of the neighborhood in which the property is located. Then there's the restriction of unreasonable occupancy limit. That generally talks about familial status. You cannot limit how many persons reside in a home. The limitation should be based on the square footage of the home and not the number of children that would reside there. So management couldn't say there's a 2-bedroom unit, but we only want one child. And there's those prohibited activity in relationship to advertisement. Discriminatory advertising, intimidation, also interference, or there may be discrimination in finance, as well as a refusal to permit reasonable accommodation or modification for a person with disability. Let's break here and talk about a situation that could be another possible housing discrimination. A tenant has an illness that requires a home health care aide who treats the tenant in-home on a daily basis. The tenant lives in a mobile home park and the owner wants to charge a visitor fee and an additional parking fee for the health aide. The tenant has asked for a waiver of this fee. Is the park required to give a waiver of that fee? Yes. The tenant has requested a reasonable accommodation. An accommodation is when a tenant or the person who requiring the accommodation asks the landlord or owner for a relaxation of the rules, policies, and procedure that are necessary for that tenant to enjoy the dwelling. Modification is landlord must allow a reasonable modification to the structure of a unit if necessary to allow enjoyment of the dwelling. And these are just some examples, but they are not just limited to these modifications. Widening up the doorway, installing ramp, installing a grab bar, lowering the counter, removing carpet. Let's get an example of a possible request for an accommodation. A tenant and her guide dog have lived in the same apartment for 20 years. The tenant has developed severe arthritis and can no longer take her guide dog outside to potty. She cannot afford to hire others to take on the task and asks the apartment complex staff to take her dog outside 3 times a day. Is the landlord required to do this? Most certainly not. The landlord has rights as well in regards to accommodation and modifications. Some of those rights are: the landlord has the right to review plans for modification. In some instances, require that the unit be returned to the previous condition. Require the person doing the work to be licensed or insured. And tenants are generally responsible for the cost of the modification, except in common area. The landlord also has the right to request information about the medical condition which shows that the modification or accommodation is needed. The landlord may not ask for the specific medical condition, but he or she could ask for a statement indicating the need for the modification or accommodation. Of course, the landlord also can deny a modification or accommodation if it's an undue burden or it fundamentally changes the business. So on the example that we previously talked about, where the tenant was asking the staff to take out the dog and walk it for her, the answer is no. That would fundamentally change the business of the landlord. Now, the Fair Housing Act applies to all buildings that were built after March 13, 1991, and with that there are certain requirements. Non-elevator building must have accessible first floor unit, and elevator building must have all accessible units. Accessibility means accessible kitchen and bathroom, reinforced walls in showers and bathtubs, accessible climate control switches and outlets. Let's talk about accommodation. The reasonable modification and reasonable accommodation provision of the Fair Housing Act only apply to housing discrimination based on disability. Is that true or false? True. The Fair Housing Act requires an accommodation or modification only on the basis of disability as defined by the Fair Housing Act. Let's now turn to discriminatory advertisement. As stated in Indiana Code 229.5-5-2, it is unlawful to make print or public or call to be made print or published any notice, statement, or advertisement with respect to sales or rental of a dwelling that indicate any preference, limitation, or discrimination because of race, color, religion, sex, handicap, familial status, or national origin, or an intention to make such preference or limitation or discrimination. So words that are indicative of race, color, national origin, religion, sex, disability, or familial status are prohibited. For example, if the advertisement says white, Hispanic, any of those things when advertising a rental ad shouldn't say preferably oriental couple or even a professional couple. The couple may mean something other than inviting for families. Now, placing ads in specific location based on a protected class may be permitted if it's for an economic reason or is affirmatively furthering fair housing. Advertisement as far as images should be inclusive. Preference shouldn't indicate from the advertisement show all race or all adult. The advertisement should be of different models, different neighborhood. It should include minority, disabled person, family with children. The ad should be, in other words, inclusive. Direction or reference to particular religious landmark when giving direction to a property in an ad should be avoided. Advertising that reference facility associated with a particular race, religion, sex, etc. should be avoided. It may not be intentional, but it could be perceived as preferential when such ads include description of a particular facility that indicate a religion or a race or a sex or so on. Steering is another prohibited activity. Steering is recommending a particular neighborhood based on racial makeup. Race should not be considered in the determination of what property to show a client, even if the client requests. While some clients may prefer to live in a racially homogeneous neighborhood, the realtor may not facilitate this preference. The Fair Housing Law also covers sexual harassment. That is, if a tenant is asked to, as we say, do this for that in exchange for lower rent or not paying rent, or if the tenant is subject to unwelcome comment from the management staff. The tenant must inform the manager, and the management must act on such complaints. After all of this information, I'm sure you're prepared to answer this question. Was a cozy 2-bedroom cottage near the St. Mary's Church, quiet neighborhood, ideal for empty nester, $700 per month? Is there anything wrong with this advertisement? The The answer is yes. The advertisement implies a preference for family without children and maybe a preferred religion. The advertisement should be as neutral and inclusive as possible. Who can file a complaint of discrimination in the housing area? An aggrieved party can file a complaint. An aggrieved party is anyone who can show that they have been injured by a discriminatory housing practice. An aggrieved party can include fair housing organization and testers. For further information, please call the Indiana Civil Rights Commission, 100 North Senate Avenue, room N103, in Annapolis, Indiana, and our office number is 317-232-2600. Toll-free number is 800-628-2909. And for those who are hearing impaired, 800-743-3333. And you can visit us online at www.in.gov/ICRC. Thank you very much for your time.